dilemma facing millions of Americans is what will happen to their lives and their legacies if they don't have a will and other estate planning documents. CNBC senior personal finance correspondent Sharon Epperson tells us how the family of a famous movie actor is now trying to figure that out.
Black Panther movie star Chadwick Boseman lost his long battle with cancer 2 months ago. Now his wife must contend with courts to determine what happens to at least part of his estate.
You worked your whole life to accumulate your property. You want to make sure that it goes to the people you care about.
That may not happen without a will. Boseman died without one, leaving nearly $939,000 in his estate in what's known as probate, a legal process that distributes assets after death. A new survey shows the majority of Americans, 62%, don't have a will. And 27% of those who do said they got it because they were afraid of death or serious illness related to COVID-19. If you're critically ill, as this attorney points out, a will is not the only key document you'll need.
No matter how much or how little you're worth, you all need a healthcare power of attorney, healthcare proxy, living will, durable power of attorney, and other financial directives to make sure that your wishes are carried out if you become incapacitated but don't necessarily pass away right away.
I read an interesting article about an African-American family in Chicago that was dealing with the recent loss of their mother. In 1986, when the mother purchased her home, she had visions of buying a home and accumulating wealth over the course of the years. And she did. She built up equity in her home. The problem was when she passed away, her family found out that she didn't have a will. The courts had to get involved, and as a result of legal fees, court fees associated with the probate process, she lost over $80,000 of equity in this home. What's tragic is in this country, 70% of African Americans die without a will. What that simply means is we're not able to accumulate generational wealth from generation to generation. So what we should take away from this article is it's important that we plan our estates, because if we don't, we're not going to be in a position to be able to solidify our financial futures and establish a legacy for generations to come.
Good evening and welcome. We are back. We are back for another night. I'm super excited about tonight. We are in our Legacy Building Generational Wealth series. It's such an incredible series that we're doing, and I'm super excited because the response that we got from last week's broadcast was amazing. I even had this. I had to wear my I Am Legacy shirt today, pull over today, because I'm just so very, very excited about this. And back by popular demand is our favorite. She's a fave now of our all. So Attorney Anelia, she's back. We're at it. Hey, Attorney Anelia.
Hi, how are you doing this evening?
I'm wonderful. Thank you so much. As you know, at last time we got started, they were already saying, bring her back. We got more questions. And I had a list of questions that people had about what you were talking about with wills and powers of attorney. And so we're going to get right into it. I don't want to waste too much time. I know that we're going to start with your new information, some new slides that we have not seen. For those of you that are just tuning in for the first time, we are not doing a lot of repeating the information. So if you go back and look on our Facebook page or on our platforms, you'll see the last week's post is already left there, and you can view that at some other time. We're only going to get to the new information today, and then we're going to fill all the questions. So any question that you have about legal question that you have about powers of attorney and how it impacts us and leaving a legacy, post them in the chat, send it to us, and we're going to get to as many as possible. Some of you have already sent me a ton. I have at least, I'll say 10 to be safe, but I think I got more like 20 questions already sent to me. But just to be safe, I'll say 10. But send it. Contact anybody who you think needs to know. Share, and we're going to go to it. Straight to you, Attorney Anelli, if you'll take it away.
All right, thank you so much. My name is Bronte Anelli. I am an attorney with South Carolina Legal Services here at the Conway office in South Carolina. And I would like to first begin by saying that although I am an attorney, I am not specifically your attorney. I am just providing some general legal information. So I do recommend that when you are ready to get your will or get any of your other advance directives, that you do contact an attorney specifically that would be able to better recommend other options that may be available to you based on your specific situation. So with that, some information I do have is a little repetitive from last weekend because a lot of things do overlap, but some things that I did want to begin with this. Do we have the PowerPoint presentation we're bringing up? If not, I can just do it on the fly.
We're ready.
All right, great. So this is the title. As I said, my name is Bronte Anelli, and that is how you spell it. Before I begin, there are a couple of types of cases South Carolina Legal Services does handle. We handle some consumer finance, employment, housing, family law, education law, probate and heirs property, which is what we're talking about today, some public benefits, and elder law. Cases that we do not handle are criminal and fee-generating cases. Fee-generating cases are things like torts, certain really type of anything that you're trying to get some type of money from. All right, so today, the topic of today is advance directives, just coming at you from a different angle. So we're actually going to be, before I begin, what is an advance directive? As I stated last week, and for anybody that is new joining us this week, it is a document that grants somebody else's authority over your affairs. This is both for you while you are living and for you while after you have passed. Now, the purpose of this is to make sure that your wishes are exactly how you want them to be handled. You can make your wishes stated at any point in time, and just making sure that your family, your friends, and the law are able to follow through with what you so desire. Before you really start looking into advance directives, there are some general things you should be considering, such as who do you trust? Who do you want to be able to make these decisions? Are these people local? Are they family? Are they friends? Are they able to make these decisions? Are they too young, too old? Who knows about your decisions? Make sure that you tell your friends and your not so much your friends, unless they, of course, are your agent, but at least your family, your desires. That way they can then help execute them if there is something wrong with a document or something like that. Keep all of your documents safe, and documents mean not only these advance directives, but any important documents that you may have. Either keep them in a fireproof box, in a safety box. I typically recommend to my clients, if they don't have those, put them in a Ziploc bag, watertight Ziploc bag, and keep them in a safe location, especially since we flood in this area a lot. That is one recommendation that I do make. Assess all of your belongings to properly know exactly how much you have to give out and how much your worth is. This is so you can properly execute your will itself. And then again, contact an attorney for assistance. So the first thing we are going to be talking about are powers of attorneys for today. A durable power of attorney can be either limited or a lifelong power of attorney. This grants your agent the ability to do any of your legal activities while you are alive but unable to make your decisions. So there are two types of powers of attorneys you can create. One is a limited power of attorney, where it only gives that agent power for so long, be it for a month, 2 months, a year, while you are unable to make your decisions. The other power of attorney is durable power of attorney. It means that it's for your entire life, even if you are able to make your decisions. Pardon me. You will need to record these within the record of deeds, and The important thing with this that I do like to highlight is that this gives your agent the ability to do everything you can do now as a person. They can buy property in your name. They can sell property in your name. They can open bank accounts, close bank accounts, buy insurance, buy stocks, bonds, any commodities. They can speak to an attorney. They can sue for you. They can be sued in your place. They have every single authority that you can give them. Now, you can limit that authority. So if you say, you know, I really don't want this person to be able to buy stocks and bonds for me, don't ever want to give them that power or even have that authority because I don't have stocks and bonds and I never want to have stocks and bonds. You can limit that power in itself, but many people just like to give everything to their agent, and that is perfectly fine. But you really do need to understand exactly how powerful these documents can be, because that person then has the ability to, without your knowledge at times, end up acting on your behalf. And that itself can be very dangerous. So definitely choose a person that you trust to be able to execute these documents. And you may want to look into a limited type of document as well. Now, depending on what you want to do with your durable power of attorney, there might be some other avenues that you can choose from. So, for example, if you just need help collecting benefits, well, you can then, for Social Security or supplemental security income, you may be able to elect a payee without having to do a durable power of attorney. You may be able to give consent through an agency to be able to talk to that person. So if you are just having difficulty for one area of your life, but you don't want to give that person everything, you may be able to come or sign over a document within that company itself. So then that one person will be able to handle your affairs at that one company. I know when I deal with banks, or when I deal with certain companies, I would have to send in something called a notice of representation. That is just permission that the client or the person gave to that company to give me the ability to speak to that company. And then once I get that, I can talk to that company all I want. And that's the same theory behind this. So if you need help, or if you need help collecting benefits, well, you might be able to get a payee status for one of your agents to be able to help you collect those benefits instead of giving out an entire power of attorney.
So as it relates, attorney, to a power of attorney, we have a couple of questions. Number one, with your talking about a power of attorney, this is an extremely, extremely powerful position that you're allowing somebody to hold in your life. Am I right?
That is absolutely correct.
Okay.
They have become you.
So they have the right to do pretty much anything that that I can do if I have not limited their abilities, correct?
That is correct.
So one of the questions that came was, can you have more than one power of attorney? And if so, can they act or operate at the same time?
We do not recommend that because of how powerful the document is. I've never heard of that being done. Not to say that it can't be done. I just know that it shouldn't be done because of how powerful it is. If you're giving 3 people the ability to make every single decision for you, well, then that conflicts with who should the company listen to? Who should the government listen to? Who should the attorney listen to at that point in time? Because then you have designated 3 different people or multiple people, however it may be, to be you. And at that point, it becomes a conflict of interest. Who is actually acting in your best interest? So I do not recommend doing that. Okay. Now, if you do have a power of attorney for one person and you no longer want them to be a power of attorney for you, you do have the ability to revoke it. So what we talked about is recording your power of attorney with the Registry of Deeds a little bit before. What you would have to do is unrecord it, re-execute a new power of attorney naming somebody else, and then re-record the newest document. And you have that ability to, so long as you are alive, to change your power of attorney at any single point in time. The only time that you may not be able to do that is if you no longer have competency, meaning that you no longer are mentally able to understand what you are doing. At what point you may be, your power of attorney may be looking for a guardianship or a conservator. And that's just naming you as essentially a power of attorney, but without your permission. This is a document that you yourself are creating while you have that mental capacity to create it, naming somebody else to be your power of attorney. So, long answer short, do not name multiple people. Name one person. If you do not trust just one person to be your power of attorney, they should not be your power of attorney. Or you can create a limited power of attorney where they only have the ability to do so much or in certain for certain lengths of times.
In the case that you have, is it possible to have several limited powers of attorney? Meaning, I know you just said not to have one person, more than one power of attorney, but if it's limited, let's say I would like for somebody to be able to handle all of my finances, somebody else to handle, whatever.
So theoretically, yes. So theoretically, you can name 3 different people to be a power of attorney, but all of their jobs do not overlap. But it might be very confusing and very difficult. So for example, you may give person A the power to have your finances and open accounts and close your accounts and work with the banking institutions. And you may have given person B the ability to hire attorneys and any other agents your family needs. Well, then person B essentially can't do their job without person A. And if person A doesn't agree with what person B is doing, well, person A doesn't have the right to make that decision, but they do have that right to possibly withhold the money for you, for your assistance. So again, when it comes to power of attorneys, I do recommend that it just be one person. And if you're trying to name 3 different people with 3 different jobs, then you need to choose other people.
Right.
Choose one person to do everything that they trust, because at that point, you're not worried about conflict between the people that you chose. You're not worried about one person withholding something that you need, because the purpose of a power of attorney is really when there's an emergency situation. So you don't want people arguing with each other when you need help and they're trying to figure out what they want for you when you just need one person to make that decision.
Right. Another question came out. Does the power of attorney have to accept this responsibility?
On our documents, we do have a place that we like our power of attorneys to sign, just saying that they acknowledge that this is what they're doing. Do they have to? I'm not quite sure about that. I recommend that they do. That way they're aware that they're a power of attorney. So they're not all of a sudden getting phone calls from banks or companies or agencies asking about what you want or what they want because you chose them as a power of attorney. So it's best that they're aware of exactly what they're required to do or that they're in charge of now.
So just to recap, what you're saying is that if you're listing somebody as your power of attorney, it's a necessary step or an important step, in your opinion, for them to notify that person that they've been made power of attorney or their power of attorney.
Yes. And in fact, I would even beforehand, before you even sign a document naming them a power of attorney, talk to them about being a power of attorney, because they might not be comfortable being one. They might say, okay, I'll do it, but I think, somebody else might be better. And that is important because you don't want to appoint somebody who ultimately is going to be hard to get a hold of. Gotcha. Or doesn't want that responsibility. Because of how powerful and how important this document is, before you even execute it, it would be best to contact them and see if that's something that they're willing to do for you.
It's amazing. Looking at our viewership last week, we noticed that we had quite a few people logging on, but many of them were, or the majority of them were older. They were, 55, 60 plus. And I'm sure that this is a great concern for them. Is there a reason, or is there any reason that a young person or someone under the age of 25 or 30 should be listening to this information, or should be aware of the information that you're talking about today?
Absolutely. And yes, they should be listening to this information. These documents are not meant just for the 50-year-old or plus group. These documents are meant for everybody at every single stage in their life. In fact, if you can at the age of 18, do it. And it might just say, Noah, I give that ability to my mom, to my dad. If something happens to me, give my mom and dad everything. That's perfectly fine. The reason why it's so important is because we are not invincible. The younger generations are not invincible. Anything can happen at any point in time. And know what? 2020 proved that. Right. And as a result, it is important that at no matter what stage a person is in their life, that they are always prepared, because that just means that, their parents are prepared. Even if they don't have children, like for myself, I don't have any children, but I made sure that my parents are prepared and my wishes are executed, and they're aware of that. So it's important for every single person, because you just never know what's going to happen. And that is actually, if you don't have any more questions, that's actually a great transition into the next power of attorney.
I agree with that. We have plenty more questions, but let's keep going.
Okay. So one thing that a lot of people don't think about getting, but is actually very necessary, especially now more than ever because we are in a pandemic, is a healthcare power of attorney. It names one person to be able to make all of the medical decisions that you yourselves would be able to make in a hospital if you are not able to make them. So as long as you are able to communicate what you want, you can make the decision. However, if you are unconscious, if you are in a coma, if you are on a ventilator, if you are in surgery and something goes wrong and a decision needs to be made, you can have an agent make that decision for you. And it is an incredibly important document as well. So some considerations for on the next slide of who you may want as your healthcare power of attorney. And some things you may want to decide on this is, do you want to be an organ donor? Do you want life-sustaining treatment? Do you want tube feeding and hydration? And although it is something that a lot of people aren't comfortable thinking about, they are very important decisions to be made at any point in time, because again, we're living in a world that we are proven more than ever before that you never know what is happening. And with an agent for healthcare power of attorney, I recommend trusting somebody just as much as you would trust them for a durable power of attorney. This person isn't making any type of not making any type of legal decision or financial decision, but what they are making is your medical decision. So definitely having that conversation with your agent beforehand, telling them what you want, and then listing it in your healthcare power of attorney can be very powerful and effective. Make sure your agent knows what you want. They are able to do it. I always recommend not choosing somebody who you know is very emotional. Because when you have to make a choice of, heaven forbid, pulling the plug or keeping you on life support, you need somebody who can make that choice for you if you give them that option. You yourself can make that choice in this document, or you don't have to decide at that point in time. So there's definitely multiple options here, but choosing somebody who will be struck with grief for months and months and months on end because something bad happened to you, I would recommend not choosing a person like that. Although I have them in my family and I love them dearly, I need somebody who in a emergency situation can make a decision knowing all the conversations we've had based on my documents that we've talked about, and can follow with what I want and not so much of what they want.
Can you add some clarity to that? Because
Yes.
in thinking of the family members specifically that we were talking about possibly being named power of attorney, I can't imagine too many scenarios in which the losing of their loved one would not be an emotional experience, at least somewhat. They just lost.
Absolutely.
So when you say someone who's not emotional, just go into a little more detail. I mean, what you mean.
Absolutely. So I'm going to use my family, for example. So to give you guys a little information on me and my family, I have brothers and sisters. We are a very close-knit group of people. We feel for each other. We love each other very deeply. We're very emotionally connected, and we're very emotionally connected. So in a situation, I know, at least from what my siblings have told me, is they have given me certain authorities for their healthcare power of attorney, because they know that in a situation, because of what I do for a living, I can make that choice. It doesn't mean that I'm not going to be emotional and crying after and absolutely distraught, but I can sit there and think clearly enough to make that decision. Right. And that's what I mean by not emotional. And I do apologize, that was the wrong terminology. It was just somebody who can think clearly enough in a situation when you hear very terrible news. Are they going to shut down, or can they think clearly through enough to make a decision and then shut down? And
that's good.
Yeah, that's somebody you need to choose, is the person who initially, for the however long, can make those decisions and help the doctor assist you in your medical statements. Now, again, you can choose a lot of those decisions yourself. If you want that life-sustaining treatment and you know you want the doctors to do everything they can possibly can in this document, you can actually make that decision. But if you don't know, you can give that up to your agent as well. So you have that ability to take some of that decision authority away from them based off of what you want. Any other questions before we go to the next slide? Because
no, that's good.
Okay. So for another document that you can decide on exactly what you want to do is a living will. A living will is almost similar to a healthcare power of attorney, except in a living will, you are just telling the doctor exactly what you want to do. Do you want life-sustaining procedures? Do you want to be resuscitated? Do you want all extraordinary life measures if you are terminally ill or unconscious? How long do you want those measures? This does not name a person to be your agent and make those decisions. This is you telling the doctors, this is what I want. Okay? Now, I do recommend that if you do not need both a living will and a healthcare power of attorney. However, I do recommend getting at least a healthcare power of attorney. Because the healthcare power of attorney will kind of cover all of the situations outside of the terminally ill or unconscious where you're in a coma type of situations. The living will just typically decides on how should a doctor proceed if you are no longer conscious or you're terminally ill and you're no longer going to be able to come out of your coma type of situations. So if you do not want an agent or do not want anyone to make that decision, but you know for a fact that you want the doctor to give you all procedures or no life-sustaining procedures, then a living will might be the better option for you. But if you don't know right now, but you're doing it just in case, then definitely go with the healthcare power of attorney, because you're making very similar, if not the same choices, but you're allowing somebody to make those decisions over you as well.
Is there any reason, I assume that a healthcare power of attorney is going to be limited to healthcare decisions?
That is correct. So the way that I think about the power of attorneys is the doors of a hospital. So for a durable power of attorney where you're making all the legal decisions, that all happens outside of the hospital doors. So any other businesses outside of a hospital or medical facility, that is what your durable power of attorney will cover. Now, your healthcare power of attorney covers everything inside. The only thing that kind of bridges the gap is paying for the doctors and admitting you into the hospital. The person who could choose whether or not to admit you is going to be the durable power of attorney, but the person to make all the decisions on whether to keep you there or remove you is the healthcare power of attorney.
So you made the statement that you don't need, and I see it in the slide, that you don't need both a living will and a healthcare power of attorney. So does that mean that the living will only covers healthcare?
That is correct. Your living will only covers your healthcare while you are alive. Your healthcare power of attorney covers your medical necessities also while you are alive and unable to make those decisions. You, again, do not need both. And in fact, your healthcare power of attorney will say, if they have a living will, do whatever is in the living will first. If the living will doesn't cover it, then come back to the healthcare power of attorney. So in fact, it does include that. So if you only want, it really just depends on what you want. If you know you in fact want the doctors to take you off life support and do not want tube feeding or hydration, and you do not want somebody to make any decisions for you medically at all your entire life, then a living will might be the better option for you. But if you're planning for other situations outside of your terminal illness or unconsciousness, then a healthcare power of attorney might be the better option for you as well.
So we got some very creative questions, and I'm going to pose them to you, and
Okay.
if I think I deem fit. So if the living will only covers healthcare information,
Mm-hmm.
let's say, God forbid, but something does happen to me and I end up being in a coma, and
Mm-hmm.
I have property that before I went into the coma, I was selling. I'm phrasing to you on the questions. Okay.
Mm-hmm.
I was selling. If I am in the coma and property that I have now is still out there being sold, who is capable of making the decision of accepting offers and conducting my business, my personal business, while I'm in the coma?
It would be your durable power of attorney.
So in that case, I would need a durable power of attorney.
Yes. So your durable power of attorney would be the person who makes all those decisions outside of the hospital. So if you were in the middle of selling property and something happened to you, then your durable power of attorney would have that ability to accept offers. There's a lot of things that can be changed upon that, but just for today, to make it as simple as possible, the durable power of attorney would be the person who would make those decisions.
Got you. Okay. Thank you.
All right. So those cover the other three directives that I was not able, I apologize, due to just the sheer amount of participation from last week to get to. So the rest of the slides that I do have available are talking about the last will and testament. And this is where I know a lot of the questions that we had from last week are coming through. So I'm just going to go through briefly. This is a recap, as Mr. Lee stated earlier on. For more in-depth information, please see last week's video. We definitely went in-depth with that. But for today's presentation and for anybody else that is new, I'm just going to do a quick review. Just in case there are any other questions that do pop up outside of the questions that have been previously sent in, okay? All right, so a last will and testament is different than the other three directives we've covered. This actually dictates what you want to happen to all of your property after you have passed. And property includes both real and personal. Real property is all of the land and homes you have or are named on. Personal property is everything else you own. So the way that I think about it is, if you take everything you own and you put it into your house and turn it upside down, everything that falls is personal property. And this also includes pets, just so you are aware. So with this, in your last will and testament, you will have to clearly state what you would like to have in it. In order you will have to make a couple of decisions beforehand, listing out all of the property, knowing its value as we talked previously, but also who you would like to have as your personal representative. Your personal representative is a person that you have named to be to help you go through the probate process and distribute your property as you have stated. The best way to think of it is your power of attorney, but after you have died.
Okay.
So your power of attorney only exists while you are alive, but the moment you have passed, then it's your personal representative. And your personal representative has all of the same authority that your power of attorney would have had just after you have passed. So they would close accounts, they would open accounts to put any money or income in. If you have businesses, they would close it up. They would help selling them. They could help sell property if that's what your choice was. They help you do what you wanted. So they help actually execute your will to make sure that it's done exactly what you want. And you also want to make sure that your personal representative serves without bond. And what that means is the court wants to make sure your personal representative is doing what you want and not secretly taking everything for themselves. So what they may ask your personal representative to do is put up a bond, a set amount of money that they give to the courts to make sure that they're doing what they're supposed to be doing. And without a bond means that you're not making your personal representative pay because you trust them enough to do exactly what you wanted them to do. Before you make a will, you do have to have capacity. You have to be over the age of 18. You have to be able to recognize what you own. So definitely going through your house and just recognizing what you actually own. If you don't own the house, but you own a portion of it, well, how do you own it? If you own a car, do you own all of it, or is it leased? Or is there a loan on it? Figuring that out, what percentage of the loan is, all of that will definitely help you be able to make your will.
That's the information I'm gonna tell you, because I received several questions, and some of them used, and I have to shout out my little sister. I call her my little sister. She's a daughter of the church, Miss Michaela Bassant, and she's in law school right now, getting ready to become an attorney. Go, Michaela.
Good for her. That's awesome.
She sent me some information, and in the information she sent me, she was talking about power of attorney, but also talking about personal representative. And I assumed that they were the same person and the same role. You just kind of shed some light on some questions that she had given me that I need to make sure that we were paying attention to. So here's my question then, since I was making the assumption that it was the same role, and it is not. And just to cover again, a power of attorney handles everything while you are alive.
That is correct.
But once you pass away or once you transition, the power of attorney ceases to have authority. From then on, your personal representative takes over or control.
That is correct. And they do not have to be the same person. If you trust one person with all of your, so for example, if you would trust your spouse with making the decisions regarding your power of attorney while you're alive. But once you're dead, you may trust a niece, a nephew, a child, a brother, a sister to be your personal representative at that time. And it can be two different people. It can be the same person. It just depends on your personal preference. And for this, unlike before, you can actually name two personal representatives. You can name one personal representative and you can name an alternative. So if something happens to your first one where they are unwilling or unable to serve, then you've named an alternative. So then that way they can serve. So it's definitely very different than a power of attorney, but it's very similar if you're looking to exactly what a personal representative can do.
So you were just saying if your first one was not able to handle the position or to carry out the wishes, then go to the second one. So I'm making two assumptions, and you tell me if the assumptions are correct. Number one, I'm assuming that only one personal representative can operate at the same time or at a time.
From my experience, that is correct. Now, again, there might be other circumstances depending on the estate size and what the court says and how it divides up. But the personal representative is sole job is to go through your entire property to make sure all the property goes to the people it's supposed to go to, and then close up the estate in probate court. And once that happens, then your estate ceases to exist and all of your property has been given to your children or anybody else that you have named. Now, again, having multiple people in this role might cause some confusion if there's a disagreement on what should happen. So, for example, if you say, I want to give my house to Jane Smith, but you know 2 Jane Smiths, well, then who do you give it to? Which Jane Smith? So not only will both Jane Smiths probably come forward, but then if there's 2 personal representatives that have 2 different interpretations, because you told one personal representative one Jane Smith and the second one a second Jane Smith, well, then who's right?
Okay.
So then that is something that, again, having one person at a time to make that decision is typically the best, because people fight over property when a person passes. It will always happen. Even if you create a will, somebody who feels like they got the short end of the stick may come forward and say, nope, I'm contesting it. I think it was completely wrong and they had no ability to do it. You just never know what's going to happen. So having one person to be in that role as the leader is definitely a better situation, in my opinion. Now, again, there's some other variables that may come to it. So definitely speak to an attorney if you do want multiple personal representatives, because it may be in your benefit and it may not. Just in my experience, one is best, one at a time.
And just to clarify for those viewers who are watching right now, the reason this information is, one of the reasons this information is so important is because the overall theme of our conversation is about building generational wealth. And the statistic we gave last time was, as of the last data that we have, is 77% of African Americans pass away without a will. And that goes from the full gamut of people who have millions of dollars to people who have very few dollars. And I think the assumption that many of us, especially those people who I've talked to since last time, is that they don't feel like they've had enough property or enough money or enough assets to have to worry about a will, or they felt like they weren't old enough to have to worry about a will. And there's a lot of property out there right now that's in limbo because they don't know who it goes to, or they're trying to go through the court process. So this provides the clarity necessary. And I honestly believe, from some of my experience of being around some families during the transitioning time, that a clear will, a clear stated will, can end a lot of the conflict and keep a family together in some cases, and honestly, from dealing with some of these necessities.
Yeah, and I absolutely agree. And to go off that statistic, the clearer a will is, the less time and money it takes into court, and the more money you will be able, and this doesn't actually mean money, it can mean property, it can mean land, that you can then give to your children. I believe one of your videos stated that a woman spent over $80,000 in equity in her home just battling out in courts. And that equity could have been given to her children, to where they then could have invested it and then just exponentially grown their own income then to give to their children and really help grow that generational legacy.
So people may not even understand. I know we played that video at the very beginning, but from a legal perspective, could you explain how that's possible? How could I, as a father, have an asset like my home, leave a will, but then, not leave a will, but after I pass away, I'm gone, but the equity of my house somehow gets eaten up? How does that happen?
So in that situation here, you have a home, you do not have a will. you still have to probate your estate, because the court needs to know, and the government essentially just needs to know, well, who owns it now? Who owns what? And that is really the question that they need to be answered. So what will happen is that somebody in your family, or to make it simple, somebody in your family will go to court to open up an estate saying, look, he didn't have a will, but this is everything with his name on it. Help me divide it up. And under law here in South Carolina, your spouse will receive 50% and your children will receive the other 50% in equal divisions. And that is called heirs property. And it is something that a lot of people in South Carolina experience, specifically in the Black rural communities, where that they have had a house that have been in their family for 10 generations. Nobody has a will, but know what? Uncle Todd is residing in it.
Right.
Well, it's not just Uncle Todd's. It's your entire family has a claim, has a percentage, and it could be 1/36th of a percentage of that home. And they still have to sign over their rights to one person collectively as a whole. Well, to hire attorneys, to open it up, to fill all that paperwork out, to pay the court fees, to take all that time, it costs money.
Right.
And as a result, you may have owned your home outright. Well, your family might then have to take a mortgage out on the home to be able to pay all those fees. So as a result, they're stuck paying a mortgage on a home that they should have owed outright. So then what happens if your spouse dies now and there's a mortgage on the home that you own outright? Well, then now your children are responsible for paying that mortgage that was received just in order to get that home settled. So definitely having a clear will make it easier on your family financially later on. Now, you can just say, well, no, I'm just going to ignore it. But somewhere down the road in your family tree, somebody is going to be handling this situation. So it just depends if you're going to handle it now or if you're going to let your great-grandchildren handle it. And the longer you wait, the more expensive it will come, because they have to find every single person that has a claim on that home, figure out their address, if they're alive, if they're dead, if they have children, if there's children, if their children's children have children. So it's a lot of investigative work that just eats into the finances more than you would expect. And unfortunately for the law, it goes a lot quicker. So definitely that's how, when you own a home outright, you can end up paying for it in the long run.
That's really good. And I'm going to let you go ahead and finish your slides because we have more questions, but time has gotten away from us. We thought it was good.
Well, the good thing is I'm almost done here. I ended up talking about the next slide, but we already talked about that.
Okay.
So then the final slide is, what if I die without a will? And again, the last question talked about that. It would be going into the estate. You would still have to probate it just like you would with a will, but then you have to figure out who owns what percentage, if they're willing to give it over to you. If they're not, you have to pay them off. And it's definitely can get very, very expensive. And every single state has their own laws. So if you're not in South Carolina, I know this is going out on the internet, definitely check with your own state's laws, because that will affect it as well. One thing that we did mention previously that I do want to mention again, if you move, or if something major happens in your life, you have another child, you ended up buying a house outright or finished paying it off, something like that, update your will. That is just to make sure that everything is clear, everything is precise, and you won't have that confusion later on in court. All right, with that being said, that is the end of my presentation for you. So if there are any questions, please do not hesitate to ask. The last slide is the South Carolina Legal Services number. As I stated before, we do handle wills, advanced power of attorneys, advanced directives, and a lot of other issues. So if you do have a question, if you would like to actually apply to see if you qualify for our services, please do not hesitate to call. Our number is 1-888-346-5592. It's a toll-free number, or you could visit our website and apply online. So with that being said, I will answer any of the remaining questions that you may have or that have come in throughout the presentation.
Great. So here's one that came out, and they were asking about personal representative. Said if you don't have a personal representative, can the court appoint you a personal representative?
Yes, the court will appoint a personal representative. It may be an attorney, and they may require your estate to pay that personal representative as they are going through your will and making sure that it is that your estate is divided the way it needs to be divided. So definitely, if you know a family member, it might be a little cheaper for that option, but a court will appoint a personal representative. Even if you appoint your personal representatives, but they're unwilling to serve, a court still will appoint somebody.
So you said maybe cheaper, that option. So are you telling me that if the court appoints a personal representative, then that personal representative has to be paid and will be paid out of the estate?
It doesn't have to, they may. And if they are required to be paid, because the court really can do almost anything the court wants within law. So if the court appoints somebody and says, well, I want them to be paid or get some sort of compensation, then that will actually come out of the estate.
Wow. But it is possible that if you don't appoint somebody, then your estate could be smaller because you have to pay somebody.
That is correct.
Wow.
Now, how much, how long it'll cost, all of those questions, every single estate is different, so I cannot answer that.
Sure.
But there are times where a court may require that.
So those of you that are watching on YouTube and on Roku and some of the other apps, I am going to tell you, there's no way for me to receive your questions on there for the next couple of minutes. So you need to log on to the Facebook page. And if you log onto the Facebook and type in the comment sections, I can see your questions and ask those. So I'm going to give it a little more time. There is a question. Miss Christine Hill asked us, said, can you talk a little bit about lifetime rights and or a life estate?
Awesome. So a life estate is a special type of estate. So this is going a little bit more into detail. So for example, you have a house and you know you want to give your house to your daughter or to your son, but you're taking care of a dear old friend who has been your roommate, your confidant, because your spouse has died. In my situation, your spouse has died, but you have a confidant who's living with you and residing in the home, and you want to make sure they're taken care of, but you don't want to give them the home. So you would essentially give them a life estate. What that means is you're making sure your roommate / confidant can remain in the home so long as they are alive. Once they have died, then it goes to who you want it to go to. So what that means is your roommate confidant does not actually own the home. They just have your permission to live in the home until they have died, at which point the full ownership of that property will go over to the person that you have decided. So that is what a life estate is.
Wow.
It's just saying that you are giving your property to another person, essentially on loan for their lifetime. And then once they have passed, then it goes to the person that you actually want it to go to. So if you have a life estate interest in something, for example, if somebody gave me their home for my lifetime, I can't sell it. I can't buy it. I can't do anything with it because it's not my home. I just have permission to stay here until I die. And then that home will actually go to the owner of the property as stated in the will.
So now this is a question that I've actually dealt with. I'm personally asking a question. Somebody has a life estate, right?
Mm-hmm.
And they are in the home, but the family members know that at the end of the life estate, the house or the property will revert to whatever. All right.
Mm-hmm.
But the person who was granted the life estate and living in the house is not keeping the house up or are making decisions they think will be detrimental to the property. What type of recourse does the family have?
Whew, okay. That, let me think here, because that is a very, it's a little complicated question,
Get ready to get
just
billed now.
because it's just a complicated question because legally that person has that right to remain in the home, but doesn't have the right to upkeep it. To really sell it or make any changes to it. The hope is always that a person uses the property and maintains it in a good quality condition. I have to be honest, off the top of my head, I do not know if there would be a recourse. I feel like there would be, but I would have to do a little bit more research on that just to figure out what would happen, because that person has a right to remain in that home under the original owner's permission. So you can't really kick them out. The question is, what can you do?
Right.
Is that something that you have to wait a little bit later, or something that you could force them to do now? And that's honestly a question I do not know, because I have never personally done something like that. So I haven't had any experience with that myself, but I'll actually do a little bit of research and get back to you on that. I apologize.
Okay, another question comes in, and I'm going to post this because it is above my pay grade. It says, Chandra Williams, she's so smart, says, can you explain the advantage of payable on death for deposit accounts and how it eliminates immediate access to bank accounts before probate is established?
I have never heard of this account before.
Okay.
So this is a question that's also above my pay grade as well. I'm actually, if you can send me that question,
I will.
Because it is a good question, and I definitely want to make sure we answer it. I do apologize. I've never dealt with an account like that before as well.
I may ask now. She's been in banking forever. So, would you post? Okay, there we go. She's posting. It is a title added to a bank account. So that might be a finance question that we might have to ask later.
Yeah, I do not know, and that might be a little overlap between the finance and probate section.
Okay.
But definitely send me that. I will do some research, speak to a couple of my colleagues, and then I'll provide you the answer sometime this week. So then that way she can actually get an answer to that question. And again, I do apologize.
That's good. All right. So another question comes in. Can the life estate give their rights up? So somebody who's been granted a life estate, can they give it up?
Yes. So you never have to accept property that you're given in an estate. So if you don't want it, you can say, no, I don't want it. And then that will then revert to so for example, in the life estate, you've given it to another person. Well, then if you gave up your life estate, that then will revert to the second person that you named. But this can go for any property in your will. And that property will then be placed in what is called a rest and residue clause. And it's essentially a catch-all clause. So any property that was not divided or accepted or forgotten in your will goes into this catch-all clause that you name one person or divide it up however you would like, and any other property remaining will then go to that one person. If you don't have that clause, then it actually will be divided up by the state according to the state laws, and most wills will have that clause, just saying that any property that was not claimed or not named but is in my estate will go to X person, or however you want it set up. And that is essentially the rest and residue clause. So if you don't accept property, it will just be dumped into this clause, and whoever is named in that clause will then receive the property in the estate.
Okay. I have a question, and I think it says, deceased siblings have, or a deceased sibling have children, or are his children included in his portion? Meaning if
If you've died without a will?
Well, that's a good question.
So typically, so it depends. I'm going to answer this question both with a will and without a will. So if you have a will and you have given property to your son and his heirs, what that means is, well, if your son has passed, but he has heirs, well, then his heirs will then receive it. But of course, you have to have other terminology in your will to ensure that that will occur. Now, if you die without a will, and you have to go through the statutes here in South Carolina, then those children will receive his percentage. So, for example, making it really simple, this is the same house example we've been working with. One spouse gets 50%. You have two children this time. The children then split up that other remaining 50%. So one child gets 25 and the other child gets 25%. But if one of those children has passed and they have two other children, so down here, then one of the deceased siblings' children will receive half of the 25th percentage, and then the second one will receive the other half of the 25th percentage.
Got it.
And that is how it will go. So essentially the way that that'll work is it'll kind of fall down like a waterfall almost until it can't flow anymore. And then that's, if you can collect, then you collect.
So just to clarify, with a will or without a will, if I die without a will and I have 4 children, well, let me use, if my father passes away without a will, okay, I have 2 siblings. I have a brother and a sister. If I pass away before my father or mother pass away, then whatever portion that was going to come to me will be, my portion will be divided among my children.
That is correct.
Okay. Now this one more question. Does that, but that portion will not be divided with my wife. It will be divided with my children.
That is correct. It's blood lineage or legal adoptions.
Got you. Once again, and I want you to restate this because this was a really big point last time about clarifying in obituaries and the reason for clarifying in obituaries. Because like I said, in the African American community, we almost look down on the word, and saying stepchild or stepdaughter, stepson is almost an ugly word now. But you were saying we need to make sure that we list it the way it legally is in the obituary. Why were you stating that?
In the courts here in South Carolina, the only people that may inherit property are your biological children or legal adopted children. Stepchildren are not inherently your children, so as a result, the courts will not force you to be financially responsible for them if it comes to any type of custody or any type of child support issues. So for purposes of inheritance, they also do not have that ability to inherit your property. When it comes to obituaries in itself, and you have passed without a will, courts will use obituaries to help determine who are the remaining heirs for that estate. So by not clearly naming in your obituary who your children are biologically and clearly stating stepchildren, it can cause a lot of confusion for the courts because they then may divide up the property to include stepchildren when they should not be, as they are not biologically your children or legally your children under the law. Now, that is why it is incredibly important to have a will, because in a will, you can name anybody to inherit that property, and that they do not have to be related to you. It can be friends, it could be charities, it could be family members, it could be your stepchildren that you have raised since they were children in your will. So that is why it is important, especially if you have that mixed family setup, to have a will, because if you do not, then you will have a child that you have considered your own your entire life no longer able to collect your estate because they are not legally yours.
Wow. And a follow up to the last question, because we were speaking before about children without a will, but with the will, my wife and I were laughing and picking at our children because the way you phrased it last time was you can cut out your children all day long. But so with that being said, with a will, the only thing that would be left to the deceased children, to the deceased child's children, would be what the parent has left in their will to the deceased child.
It depends. So,
Okay.
so the way, and please correct me if I think I might be understanding this incorrect. So you have you have named your own child in the will, but then your child has passed before you did. So now you are trying to leave the remaining property to their children, correct?
Yes. So COVID has brought about a lot of changes, and some people that we never anticipated leaving so soon have left a lot earlier than we anticipated. And so if, as a parent, I left in my will a portion to a child that since has passed away, all right, does that automatically, without me altering my will, when I left him or her, does that automatically go to their children?
No.
No. Okay.
It will not automatically go to their children. It will essentially, when you have passed, the court will look at what property you have and who is currently still alive. And they will then match up the property to those who are still with us. So if you do have a family member who you gave property to, but who has since passed, and that property is no longer covered under the will anymore, then it would be best for you to redo your will. Now, that property, so for example, using your children again, if you have 3 children,
Sure.
and you said you divide it equally, well, then when somebody has passed, heaven forbid that never happens,
Sure.
then the property, instead of being split 3 ways, is now split 2 ways.
Okay. Wow. Okay. So that's a big difference.
Yes.
Because what you told us is without a will, it would remain split the way with among the children. And if one of my children were deceased, it would automatically go to their children. But,
so there's, sorry, go ahead.
But if I left in my will that all of my assets would be divided among my children and one of them passed, then it would then be divided among the remaining children, but would not revert to one of my children, the deceased child's children.
That is correct. And there are ways you could get around it. So things that we're not going to cover today because they can be very complicated is like a trust. So if you still want that property to be going to your grandchildren of the child that has passed, you may want to put it in a trust for them. So then that way, when they become of age, that property is still theirs. That might be a possibility. So there's a couple of different ways you may be able to get around it.
Wow.
But the reason why it doesn't automatically go that way is because you really, we're getting more into the weeds now, but you really just in a will should name exactly who you want. And if there is a change of circumstance, then definitely redoing your will would be best. And the bigger change of a circumstance, the more you should redo a will, because even if you have a will, but it hasn't been updated in 15, 20 years, but let's say you won $1 billion in the lottery, well, then guess what? They're still going to be fighting over that in your estate.
Right. So as you can see, the more questions we have, the more complicated it gets. And so the purpose of this session is really just to make sure that everyone goes out and does their due diligence. If you were not here at the very beginning of the broadcast, then what Attorney Anelli was telling us was that although she is offering information, she's not offering advice to anyone. And she is telling everyone, you need to go and get your own representation. That's why then we left the slide with South Carolina Legal Services on. For those of you that are in South Carolina, they can tell you whether or not you qualify for their services and point you in another direction if you don't. And so it's really important, really, really important. As you can see, the frustrating part is that when it comes down to doing the business of our families, oftentimes we will have people who are so frustrated that they leave things undone or don't want to get involved. And I think what you said earlier was so profound, that whether or not you want to do it is up to you, but whether or not it has to be done or will be done is not. Somebody in your family tree is going to have to do the work. So you aren't eliminating the work. You're just pushing it off to somebody else who's already going to have to be dealing with the pain of you being lost from their presence and from their life. So I think it's important. Attorney Anelli, I cannot thank you enough. We could keep you here for another session, but I am grateful. We are going to get into some extremely exciting things, and I hope that we have treated you warmly and to the point where you would be accessible, possibly if we find that another aspect offers more legal questions that we need to ask.
Absolutely. I absolutely enjoy being here with you. It is such a pleasure. I can't tell you how much I do enjoy it. So anything you do need, do not hesitate to get in contact with me. I would be more than happy to do this or talk about some other things that we do here at Legal Services for you and the community at large.
Absolutely. I'm so proud. And once again, before I close, let me thank publicly Sister Nettie Edie for putting all this together for us. And this session, I think, is wonderful. She's a godsend. We absolutely love her. So much love to her. Thank you, Attorney Anelli. Anything you want to say before you leave?
I just want to again thank you, and please do not hesitate to give us a call here. Just give us a call, apply for our services, and we will be able to see what we can do for you. If we can't, as Mr. Lee stated, we will be able to point you in the right direction. So it's never too early and it's never too late. Any time is a good time, especially tomorrow or today.
Thank you so much. I appreciate it. Talk to you soon.
All right. Take care.
You too. Listen, those of you that are watching, this is an incredible series, incredible season, incredible session that we've gotten a chance to get involved with. And this is, I did not shout them out earlier and talk about them, but this is something that's not new to Mason Temple. Our pastor has been, Superintendent James L. Lee, has been a huge proponent of making sure that we are not only conducting our lives inside of the sanctuary godly, but that we are living lives that are more abundantly. Christ told us that he came that we not only would have life, but that we would have it more abundantly. So we have to make sure that we are handling the business. These times are unprecedented. And with unprecedented times comes issues that some of us have never really paid attention to. There is a huge generational wealth gap, and the gap is getting larger. One of the things that we looked at was that millennials are the greatest amount of people right now in the workforce. But even though they are the largest demographic of people in the workforce, the wealth gap is increasing. So you would think with more of them in the workforce that it would be narrowing, but it is increasing. So there are a lot of things that we have to do to make sure. Proverbs tells us that a blessed man leaves an inheritance to not only his children, but his children's children. But we have to be intentional. We have to be intentional. We have to be intentional. So I'm excited. I can't let all the cats out the bag, but I want you to be ready. Every Sunday, we're going to be coming to you with another one. And if everything goes the same, next week, we're going to be talking about something extremely powerful. We're waiting on the confirmation, but it may seem a little weird, but next week, if everything works out, we are going to be talking about veteran benefits and how it can really impact your generational wealth. There are things that you can take advantage of, our veterans, that could impact not only improve the quality of life that you have, but also steps that you can take that will improve the quality of life of your children for the remainder of their life. There's a lot of information that we just don't have and have not had access to. And since VA benefits and veteran benefits, since the GI Bill, even before that, for a large percentage of Americans, has changed the canvas of their family. And it has not changed the canvas of all of our families, and we know the history. But as we are now progressing in time, we have to make sure that we are demanding and taking advantage of all of the benefits and resources that are afforded to us. So tune in next week. It's going to be powerful. It's going to be great. You can go ahead and get your seats ready. We're going to put our flyers out and our information out so that you can have your questions ready so that you can go ahead and access it. This is our legacy series, Establishing Generational Wealth. Until then, you all be blessed and have a wonderful night.